in the Southern African region and presents a major obstacle to attaining gender equality and equity. Like my colleague has just said, the battered woman is not an empowered woman. So gender-based violence leads to poverty, and it stops growth of the economies of the countries when women are battered, even when men are battered as well. Gender-based violence, it also covers a lot of things. It could be sexual harassment in the workplace, it should be domestic violence, it could be human trafficking and sexual and emotional abuse, just to name a few. It is a great honor and privilege for me to be talking to this august house, if I were to call it. I would actually like to thank the SADC Parliamentary Forum for coming up with this together with the SADC Lawyers Association. This is very important, a very important subject in the law. And I also want to say, when we talk of human rights, we are talking of the rule of law. And when we have gender-based violence taking place in the SADC region, what it means is that we are actually flouting the rules and regulations of the rule of law. I want to say thank you all for making time to participate and to contribute. The resolution to develop the SADC Model Law on GBV emanated from the SADC Parliamentary Forum, Regional Women's Parliamentary Caucus, RWPC, during the forum's 44th plenary assembly session held in Maputo, Mozambique on the 26th of November to the 10th of December 2018. The RWPC sponsored a motion to develop a model law on gender-based violence to be utilized by SADC member states to prevent, address, and eradicate these forms of violence. The motion was unanimously adopted and consensus was reached by stakeholders working in this area to proceed with the development of a SADC model law on GBV. The development of the SADC model law on GBV complements various ongoing initiatives that have been undertaken by the region to eliminate GBV. Despite the existence of these initiatives, gender-based violence remains endemic in Southern Africa member states and constitutes a threat to peace, security, and to the achievement of our global developmental goals. Today's consultation process will ground us in context overview on the background theoretical papers covering gender-based violence as a human rights issue and shortfalls on GBV legislation in the SADC region, followed by the presentation of the draft model law by Ms. Eva Jahala, and together we will undergo a plenary to make interventions which will be considered in view of consolidating the model law and alignment of positions to infuse into particular sections of the model law. In particular, provisions of the model law will be discussed for confirmation amendments in the light of the feedback received. Wish you all a great and fruitful time, fruitful deliberations. I thank you. Muito obrigado. Merci beaucoup. I thank you.
Thank you very much, Madam Vice President of SADC Lawyers Association, for your very powerful opening sentiments. Thank you so much. We appreciate the presence of SADC Lawyers Association, and I'm certain that with the engagement, the model law could only be richer because, as the Secretary General pointed out, although it captures the best international practice, it's important that we must ground it to our own realities. I think that is where the SADC Lawyers Association comes in. Thank you very much, Madam Vice President. Now, it's my singular honor and pleasure to call upon my good friend, time-tested friend. I don't know whether she's there, Sanji Monaheng. I haven't seen her in the longest time, so this is my only opportunity to see her if she appears at all. So Sanji Monaheng, Sanji is the former judge of the International Criminal Court and now a judge at the SADC Tribunal. Welcome, my lady. The opportunity is now yours. The respect I all give to you.
Thank you so much. Can you hear me, Judge?
Yes.
Oh, thank you so much, my dear colleague. Excellency, the SADC Parliamentary Forum Secretary General, Meboemo Sokhoma, who is also my daughter, the Vice President of the SADC Lawyers Association, Mevimba Nyemba, the Executive Member of the SADC Lawyers Association Executive Committee, Law Society of Namibia, Council Representative Matt Clot, Excellency, Honorable Justice Professor Kidingake, my dear brother, SADC Model Law on GBV Legislative Drafter, Me Jala, Me Beatrice Mateo, GBV Community Advocate, honorable members present here, the working group on the SADC Model Law, staff of the SADC Parliamentary Forum, dear colleagues in the legal profession, members of the media, ladies and gentlemen. It is with great honor and pleasure that I address you today as the Southern African Development Community Parliamentary Forum launches the stakeholder consultation process for the development of a model law on gender-based violence, GBV. The proposal to develop a regional model law on GBV emanated from the SADC Parliamentary Forum Regional Women's Parliamentary Caucus during the forum's 44th plenary assembly session held in Maputo, Mozambique, from the 26th November to the 10th December 2018. This motion was adopted in recognition of the endemic nature of GBV, its multidimensional effects, and its devastating impact on the lives of innocent women, men, boys, and girls in the SADC region. GBV is not only a problem in the private sphere, it continues to be a threat to human security, peace and development, and to the achievement of national, regional, continental, and global development goals. GBV has drastic social and economic consequences at the national level, and it remains amongst the most severe and widespread human rights violations in Southern Africa. Previous speakers have ably articulated all the problems that are attendant to GBV. While 1 in 2 women have experienced GBV at some point in their lives at the global level, some countries in the SADC region have higher instances of GBV. The emergence of COVID-19 has exposed the structural discrimination and inequalities faced by women and girls and their marginal position in society. Throughout the region, reports of abuse such as intimate partner violence, sexual harassment, child marriage, female genital mutilation, domestic and sexual abuse of women and girls, online abuse, harassment, and exploitation of children have increased by 20%. In Tanzania, for instance, there are emerging new harmful practices due to COVID-19. There has been an increase in marital rape in Eswatini, and GBV has cost the South African government 1.7 billion rand. SADC has adopted various regional frameworks and tools to comprehensively tackle GBV in a coordinated manner. Key amongst these are the revised Regional Indicative Strategic Development Plan 2015 to 2020, the Strategic Indicative Plan of the Organ on Politics, Defense and Security Cooperation, the SADC Protocol on Gender Development, the SADC Gender Policy, and the Regional Strategy and Framework of Action for Addressing Gender-Based Violence. Despite these efforts, SADC faces different challenges in the response to GBV. Key amongst these challenges are inadequate and outdated national laws on GBV and inadequate gender disaggregated statistics. It is envisaged that the SADC-PF Model Law on GBV shall guide SADC member states in the ratification, domestication, and implementation of relevant international and regional principles, guidelines, and obligations that inform GBV prevention and response interventions at member state level. And I'm happy to say that recently the Botswana Parliament agreed to the formation of an inter-ministerial committee on GBV, which hopefully will start work soon. So for us, this seminar and this model law comes at a very proper time. Your Excellencies, distinguished and my learned colleagues, fellow participants, I call on you to use this model law as a yardstick to measure your domestic laws and to develop, enact, and reform as may be relevant to ensure that the SADC region meets its international, continental, and regional commitments. And to the SADC Lawyers Association in particular, I would really appreciate it or be proud if you can talk to your member law societies and bar associations to keep an eye on what is happening and to use this document to guide their members and to guide their states parties or to guide states parties. Ladies and gentlemen, I wish you a fruitful deliberation and I thank you. Muito obrigado. Merci beaucoup. Thank you so much. Thank you, Chair.
Thank you, Sanji. Thank you, my lady. Thank you for your very profound sentiment. So there is a cost to am I clear?
Yeah, you are.
Oh, okay. I can continue. Yeah. As the keynote speaker has just pointed out, it's a very pervasive problem, a threat to human security, peace, and development. And it's quite alarming that you say that 1 out of 2 globally of women have experienced some form of gender-based violence. So the situation is not very different from our situation in this part of the world. So thank you very much. And now I'm going to, without wasting time, I'm going to move to my segment. Just to give you some background paper or papers, there are 2 basically, theoretical papers on gender-based violence as human rights issue, and also shortfalls on GBV legislation in the SADC region. The time allocation aspect also including discussions. So by necessity is going to be an overview of what is at stake when we speak about gender-based violence. Let me just start with dress and caliber, including lawyers. It's plain to me that I would be excused in not going into any detail about what human rights is all about. But it's worth refreshing and emphasizing this one singular point, that human rights are entitlements that accrue to all human beings. All human beings. That includes men and women. It includes boys and girls. That aspect of things should be non-negotiable. And these rights are not given to us by the state. So we are not at the mercy of the state in order to enjoy our rights. They accrue to us by virtue of being human. Yet, and the issue of human rights in the global space has long been recognized decades and decades ago. You can go as far back as even prior to the 1948 Universal Declaration of Human Rights. But tragically to date, we still have a situation where human rights are contested. We still have to sometimes to struggle to pay the ultimate price for demanding that which really we should not be demanding. That is so in the space around women's rights. And I was chuckling to myself, having taught human rights at the University of Botswana, that I do not remember seeing a single unit of any module on human rights at university around gender-based violence. And the standard menu is the civil and political rights, socio-economic political rights, but to drill down on gender-based violence, I think still has to find a pride of place in many curricula at universities. I think this needs to be remedied. There are many definitions of gender-based violence, but the one that I find simple, a working formula that we can carry with us, is that it is violence directed at a person because of their gender. That is what gender-based violence in essence speaks about. It is deeply rooted in gender inequality, continues to be one of the most notable human rights violations. It is experienced by both women and men, girls and boys, but most of the victims are women and girls. As a consequence of unequal power relations, and as the Secretary General put it, unequal power dynamics in many spaces, at the home, at schools, at work, we find gender-based violence. SADC has high rates of gender-based violence against women and girls. And violence from an intimate partner is quite pervasive. And as the Secretary General poignantly pointed out, and I keep repeating this because I think it's at the heart of matters, a battered woman or a woman who is a victim of gender-based violence cannot be empowered to participate in decision-making, to participate in the economy, to work with dignity, and simply to live like a human being. Now, since I am speaking to lawyers, I think I must say the obvious to emphasize one important thing. Within our national frameworks, within our own countries, we have laws that deal with issues of gender-based violence or deal with issues of human rights or of equality. And the Vice President of SADC Lawyers Association spoke also that when you talk about human rights, you are talking about the rule of law. And this is contained in our constitutions. But in addition to that, that is a point I want to emphasize. Our constitution in SADC, our constitutions in SADC protect women's rights in varying degrees. Some constitutions have more shortfalls or gaps than others, especially when it comes to issues of gender equality, definition of gender discrimination, and so forth. So I want to say this, that our inadequate legislative framework at the current phase in our own countries can be supplemented by international law, depending again on whether our legal system is a dualist legal system or a monist system. As you know, in a dualist legal system, international treaties that are ratified by our countries have to be domesticated in order to become part of the national law. And in some countries which have self-executing treaties or have monist characteristics, they are better off in the sense that it is easier to enforce international law more directly compared to dual legal systems. But lawyers have an opportunity. Lawyers have a great opportunity within the dual legal system or within the monist system to tap into international law that is generally more protective of women's rights, either as soft law, the declarations, the resolutions. There's also the International Bill of Rights that we can always invoke. I spend a little bit of time on this point because I am talking to lawyers. While as we are waiting for a fully fledged, fully protective legislation in our countries, that may take time and that may still have to be inspired by the SADC model law that we are working on. Lawyers can resort to international law. There is a growing tendency of national courts now to have regard to international norms for the purpose of deciding cases where the domestic or constitutional law or statute law has some deficiencies. So in effect, I am referring to the Bangalore principles. The Bangalore principles are very important in eliminating the rights discourse, especially where there is some inadequacies. In effect, the Bangalore principles state that international law, although it's not as such part of domestic law, in most Commonwealth countries can still be utilized. Such a law does not become part of domestic law, as I said, until ratified. But it can still be utilized where there is uncertainty and where there is ambiguity. We can resort to international legal instruments. So the International Human Rights Instrument is not a single document, but a system of conventions, treaties, declarations, resolutions, committee reports, and so forth. And it includes the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, all of which were drafted under the auspices of the United Nations. These instruments are critical in advancing human rights, in dealing with the scourge of gender-based violence in our countries. There's also the African Human Rights Framework. The African Union Agenda 2063 that the Secretary General alluded to identifies gender-based violence as a major obstacle to human security, peace, and development. Exactly what my sister Sanji Monaghan spoke about. This is gender-based violence, particularly pronounced and in conflict-ridden areas. Many Sustainable Development Goals of 2015 also provide opportunity for the prevention and mitigation of gender-based violence. In particular, the following SDGs articulate themes that directly address factors that contribute to GBV. SDG 1, no poverty. SDG 3, good health and well-being. SDG 4, quality education. SDG 5, gender equality. SDG 8, decent work and economic growth, and SDG 10, reduced inequalities. So these are very important resource material in order to advance human rights of women against gender-based violence. Now, the situation in the region is of concern. GBV legislation in the region has significantly improved. Although the uptake of GBV services although it is improving, there are issues around the provision of places of safety. And that is a concern. Gender-based violence can take many forms, and depending on the type of relationship that is the context, you find that there are issues of power dynamics at home, at the workplace, in the broader society. And at work, there are issues of sexual harassment that need to be attended, which is a violation of fundamental human rights. GBV, as I said, in terms of many of our constitutions, sometimes does not quite find a pride of place. Now, in terms of the international legal instruments that I've spoken about, the United Nations General Assembly at its 47th session agreed that the violation of human rights of women was not limited to acts perpetrated or directly condoned by governments. We are speaking here of issues of rape, issues of genital mutilation, issues of murder, and all those issues. Agreed that the violation of human rights of women was not limited to acts perpetrated or directly condoned by governments, but rather governments bore, and this is important, have a duty, a social and political responsibility. I will also add a legal duty to ensure that women are not unnecessarily victims of gender-based violence. In situations where governments are not taking any action to pass the necessary legislation to protect women, they are de facto accomplices in the violation of rights. According to these criteria, the state becomes a de facto accomplice if it does not offer women the necessary protection from violations of their rights. And lawyers are among the privileged few who can project and illuminate the status of being a de facto accomplice when governments don't take action in order as to advance the rights of women. It can also be credibly argued that the incapacity of states to put an end to social, economic, and cultural conditions that expose women to gender-based violence means that it is responsible for such violence, since it should actively contribute to eradicating injustices and inequalities that manifest themselves in gender relations. There are issues of reporting. As you know, women hardly report these issues, and we know the reasons why they are not reporting. It's on account of many considerations, including cultural expectations. Gender-based violence in the household is a behavior pattern that has become assimilated as a type of marital relationship. There is a societal expectation that women should not wash their laundry in public and all those kind of considerations. Sexual harassment at the workplace is quite prevalent. It's one of the gender-based violence forms that we hardly talk about. But the equality of opportunities for men and women in the labor market is jeopardized by the sexual harassment of women in the workplace, and we need to attend to all this. Now, that was by way of just an overview of the human rights, gender-based violence as human rights. So in conclusion, concluding this part, because I still have to go on an overview of the gender-based legislation, the gaps and shortfalls, let me conclude this section by saying, I have sought to demonstrate that human rights are important. Although they continue to be contested, lawyers can play a very important role in ensuring that they bring on board international law to mitigate any inadequacies that may be prevalent in national legislation. So I'll proceed to the next segment so that we can then combine the two, because the two are related in the discussions, to just give an overview now of the gaps, shortfalls in GBV legislation in the SADC region. The Southern African Development Community Protocol on Gender and Development seeks to promote gender equality in the SADC region. And dealing specifically with the GBV, Part 6 of the SADC Protocol, requires states that by 2015 they should have enacted appropriate laws prohibiting all forms of gender-based violence and ensure that perpetrators of gender-based violence are brought before the law to account. And one of the people who ensures the enforcement are lawyers, whether in the DPP or in their chambers, litigating on behalf of their clients. They can ensure accountability where there are laws that are in existence. Generally, all laws and policies have different implications for both women and men. Evidence shows that despite the existence of these laws, gender inequality is still widespread in the region because of existing gaps, and not only existing gaps, but also limited enforcement of these laws. Even in countries that generally have done well, like South Africa, they still experience the challenge of enforcement. I think it's important to highlight that. Now, this is the situational analysis of the state of GBV legislation in the SADC region. And as I said earlier, although GBV legislation in the region has significantly improved and the uptake of GBV services is improving, there are still some challenges. 11 SADC member states have laws on domestic violence, and 13 have sexual assault legislation. With the exception of Angola, all SADC member states have sexual harassment laws, up from only 2 in 2009. You'll agree that is some appreciable progress. From 3 in 2009, being Madagascar, Mozambique, and Zambia, all SADC member states now have laws on trafficking in persons. All member states offer some form of services to survivors of GBV. However, the main challenge remains that service providers are mainly under-resourced. There are still challenges around sexual and reproductive health laws. They are generally inadequate. The enforcement of them is even more unsatisfactory. Provision of comprehensive GBV treatment has increased from 2 SADC member states in 2009 to all member states. There are gaps, and in some situations, huge gaps in the legislation. We have no time to go through all those, but I'll just give you a flavor by a very quick summary of the state of play. The legal framework in 12 member states still discriminate against women, as they either do not define what constitutes discrimination against women, or if there are any definitions, those definitions are unsatisfactory. There is limited access to justice and legal aid for women facing GBV in 13 member states, especially rural women and women with disabilities. Negative attitudes were noted amongst health professionals, law enforcement agencies, and prosecutors towards victims of GBV. There was criminalization of abortion in 13 member states, resulting in unsafe abortions and high mortality rates. So in this one of actually the areas in the SADC region where there is a very huge gap. There are issues around child marriages. I know SADC-PF has pioneered the model law on ending child marriages. There are big issues and big gaps around legislation in the SADC region governing child marriages, and that gap needs to be closed. GBV in schools is quite prevalent. Regarding education, in 2 member states, Angola and DRC, girls were subjected to sexual gender-based violence, including rape by their school teachers and peers. And that is not only in Angola, it's actually prevalent across the region. There is criminalization of abortion. There was criminalization of abortion in 14 member states: Angola, Botswana, Lesotho, DRC, Eswatini, Madagascar, Malawi, Mauritius, Mozambique, and Namibia. There are still challenges in that aspect. Sexual reproductive health rights laws are also inadequate. Research has shown that at least 1 or more policies and laws that cover family planning, adolescents' access to sexual reproductive health rights, HIV and AIDS, teenage pregnancy, safe abortion, sex work is very scanty. Criminalization of child marriages. Only 4 member states, Eswatini, Madagascar, Tanzania, and Zambia, according to the literature that I read, have criminalized child marriages. The remaining 12 member states either do not have child marriage legislation, or if there is, it's inadequate. Generally, a number of countries that have ratified international conventions have not domesticated them. The result of this is that there is inadequate protection of human rights in the region as a result of a very high record of ratifying treaties, but a very low record actually of domesticating these treaties. And I am certain that the model law is inspired by international law. So we must be careful that it doesn't suffer the fate of international law, where it is done, dusted, agreed, this is best, but it does not find its way to our national parliaments and our own societies. The issue of marital rape, I think it was Justice Sanji who mentioned the issue of marital rape. There is an increase in marital rape in most of our countries, but not many of our countries have criminalized marital rape. The old common law still rules unabated in many of our countries. In a number of our countries, we still have the law requiring corroboration in rape cases because there appears to be some inherent, bizarre, and unexplainable belief that the testimony of a woman victim to rape must necessarily be suspected. So we still have vestiges of those kind of law where the law insists on corroboration and the lawyers in court hold on to that element as if their lives depends on it, if they want an acquittal at all costs. Sexual harassment laws. I have talked about it, but here I want to give some little details. Sexual harassment is prohibited in all 16 member states, but there are few avenues of recourse for victims and poor support systems for survivors. Issues around online sexual abuse. There is limited recognition of online sexual abuse, exploitation in cyber laws, and very poor protection of survivors against cyber GBV in all 16 member states. 6 member states have standalone cybercrime legislation: Botswana, Madagascar, Malawi, Mauritius, Namibia, and Tanzania. Generally, I want to conclude by citing a few examples of specific legislation in 2 countries. I do so to contrast. The first one is in Tanzania, and the last one is in South Africa. Generally, I have found in the literature that among the many SADC countries, South Africa is quite advanced in terms of protective laws, although there are challenges of enforcement. In most SADC states, there are provisions similar to Tanzania on marriage laws, on sexual offenses laws. In Tanzania, the Law of Marriage Act, revised in 2002, has various loopholes which caused infringement of women's rights and abuse, such as polygamy, to continue. The law recognized customary law, which impinges women on equal division of property. And this kind of law is quite common in the region. In sexual offense special provisions, marital rape has not been considered or prohibited. And again, this is quite common in the region. The South African Constitution is quite admirable in the manner in which it has protected rights. The Constitution guarantees a number of protections against GBV. This includes the right to equality, equality before the law, equal protection of the law. Section 10 of the Constitution guarantees the right to human dignity, which is not there in many constitutions, although it is the bedrock of human rights generally. I am a bit apprehensive of time because I happen to be the chair and the speaker. I have no idea how I'm doing for time. I'll err on the side of abundance of caution and conclude my paper to say, I have sought to suggest to give a very broad overview of the state of GBV legislation in the SADC region, focusing on some gaps and shortcomings. And although it is fair to say there's been some improvement, there is still a lot of ground to cover that the SADC model law will go a long way in closing these gaps in the long term. Thank you. That concludes my discussion. We have 5 minutes for plenary on them. I don't know whether I'm still heard over there.
Yes, you are. Thank you.
Yeah, yes. So we can go into the plenary. Are there any comments on the papers I've delivered before we proceed to the next item on the agenda? Any comments? Sanji Manaheng has a hand is up.
Yes, Judge, my hand is up. It's just a comment, especially directed to the lawyers. I really must thank you for your presentations. I liked the part where you are saying that states should be considered de facto accomplices if they don't act. But I'm also saying to the SADC Lawyers Association, I don't know whether any of the chapters or the association itself prepare shadow reports for presentation to the African Commission when states present their 2-yearly reports. And if they do, I'm not quite sure, I'm just saying things. If they do, I think they should highlight the issue of GBV. They should name and shame states parties, and that they should make sure that their chapters start presenting, compiling shadow reports. In Botswana, a long time ago, some NGOs used to do that. They were consulted, but I'm not too sure if the Law Society of Botswana was ever consulted. So perhaps we should move towards that. Make sure that when Botswana, for instance, submits her 2-yearly reports, and when there are consultations with the NGOs, they make it a point that they participate. Thank you very much, Judge.
Thank you so much. Thank you, Judge. That was a comment. Any other comment or question? We have about 3 minutes.
Mr. Chair?
Yes.
I'm Yogeshni Naika, and I'm from
Yes.
South Africa. I'm from the National Association of Democratic Lawyers, and
Yes.
I'm from the Executive Committee of the Law Society. In your presentation, you spoke about the empowerment and the position of us legal practitioners. What I want to draw to your attention, because you also spoke about the workplace, is that I was one of the youngest attorneys to be appointed to a law society. And when that happened, we began to open discussions regarding the place of young people in the workplace, especially those candidate attorneys and the articles of contract. And what I brought to the table was the experiences I have had amongst young lawyers in South Africa. There is a lot of sexual abuse by our own kind, our own attorneys, senior attorneys, and there is not enough protection within our profession, and that is shocking. Thank you. And I think that is something that all law societies in our countries, if we have a model where there's a senior attorney mentoring a younger attorney, there will always be opportunity for sexual abuse. Thank you.
Thank you very much, Naika. I think that is quite profound and a serious indictment if it does take place within our ranks. Our ranks, I'm talking about the legal fraternity that is also supposed to be conscious of rights and protect rights, because the bar must protect rights. But I also think it also speaks to introspection, self-introspection. I think the law societies in the region, I think the vice president of the law societies there, I think they need somehow to put in place some standards, some norms, even within workplaces like the law firms, advocate chambers, that will go a long way to help. Thank you. Thank you so much. One last speaker. Are they cross lines or something?
I think they are cross lines. Good afternoon. Good afternoon. Good morning, sir.
Yes. Yes, good morning.
And good morning to fellow participants. This is Moromokolo from the Republic of Botswana, but based in South Africa. Yes. Interesting conversations that I've just had. I have two questions. One of them is just a comment. The internet, and my question is, what role will the new model law play in addressing the impact of technology, especially on GBV? What does the new model law say about the law? Now, in the fraternity, in the space of the persons who are here present, I know they're specialists in law. I'm not a lawyer. I mean, in the academia, different field altogether. However, social media law and media law. Those of you who are specialists in media law, I'd like to hear from you. What role has the media across the SADC region played in either perpetrating or assisting or condemning GBV? That is my take. Thank you very much.
Thank you very much, Moromokolo, for your comments. I didn't know you crossed the border.
A long time ago.
But thank you. I hope that when Eva comes to make a presentation on the model law, because it's going to highlight some key provisions, part of your answers, if not all, will be answered. If they are not, I think she's also taking note on what the model law offers, the opportunities that you talk about, the internet and all that, the role of social media and the media generally. Just 2 weeks ago, I think I was addressing SADC editors in a conference talking about bodily integrity and autonomy. And I think we agreed that there is still a lot to be done. Firstly, even before we go to the law, in sensitizing them about what is at stake and what is their role. Because it's one thing to have laws. You can have laws, good laws, progressive laws, but unless you transform minds and individuals, then those laws just become buried in a piece of paper. But thank you very much for that. I'll close this session because of time considerations and move to the next phase. I think it must be you, Eva. I'm checking my program, yeah? Is it you, Eva?
My program says statement by GBV witness.
Yes, it is. Okay, it's not you. It's statement by Beatrice. Beatrice, are you there? GBV community advocate in Malawi.
Yes, I'm here.
Please go ahead.
Thank you. My name is Beatrice Mateo. Oh, sorry. Let me observe the protocols first. The SADC-PF Secretary General, Ms. Boem Sekoma. I'm sorry if I pronounce the names wrong. Honorable Justice Sanji Monakeng, Honorable Justice Professor Ki Dingake, SADC Model Law on GBV Legislative Drafter, Ms. Eva Chala, honorable members here present, SADC Model Law on GBV Technical Working Group, staff of the SADC Parliamentary Forum, members of the media, ladies and gentlemen. My name is Beatrice Mateo. I'm founder and executive director of a local NGO called Coalition for the Empowerment of Women and Girls. I am a survivor of gender-based violence. I think part of that has led me to forming my organization, because I wanted to make sure that no woman or girl faces the traumatic experience that I faced. I was defiled at 10. When I was married, I faced a lot of gender-based violence, including marital rape. In my experience, also working with other women, I have observed some things that maybe could be addressed by laws, or if they are in the law, maybe they are not working in practice. The issue of psychosocial support, I think mostly, I don't know whether the laws actually talk about it, that it's not being implemented, or if it's not, I think it needs to come from the aspect of laws that the survivors should be offered psychosocial support. Mostly it focuses on the perpetrator in terms of punishment and not the reformation. If you look at issues of counseling, I think it is important to make it mandatory for perpetrators of GBV to undergo counseling so that they are reformed. Also, the issue of register of offenders. I know in my country, I don't know about the other countries in the southern region, that is glaringly missing, which I think contributes to repeat offenders. In some communities, we have seen offenders that, do the act 3 or even 4 times. They go once, they come to the community, they do it again, and then they go back. Also, the issue of shelters is in most cases absent. You find that most women, especially in the married context, most women go back to the abuser because they have no options. They have no shelters in their community. The other thing that I have seen in my work is working with most GBV survivors will go to the informal mechanisms. So we have traditional leaders, we have religious leaders, and other informal mechanisms, which I think in most cases it's because they are easier to access. There's no bureaucracy, even in terms of distance. So I don't know how the issue of laws can embrace the informal sort of mechanisms that currently people are accessing. The other issue is our law enforcers taking on issues of sometimes accepting withdrawal of cases because, the perpetrator is a breadwinner, and then the victim or the survivor has opted to withdraw the case because then they are afraid they are not going to be able to survive on their own. The issue of stiffer sentences for perpetrators, I think that needs to be emphasized for states so that, that maybe can act as a hindrance for other would-be perpetrators. You also talked about the issue of marital rape. I think I should emphasize that it's a very big issue. When we talk to women's groups, they talk about issues of marital rape, but since it's absent, especially in my country, it's absent, that it's not recognized as an issue. You find that most women suffer in silence. Also looking at issues of social cultural norms and attitudes, where women are told that, they shouldn't talk about these issues, they should resort to prayer, they should preserve the respect of their husbands. That makes it very hard for women to come out. And also in some cases, for women like us who are advocating for other women's issues, we face GBV now by state institutions or state machinery, which then also affects how we respond to the issues that we face in our community. I think that's what I wanted to share with you this morning. Thank you for having me.
Thank you very much, Beatrice. Thank you very much. We appreciate, I think you have said very important issues around the counseling of perpetrators. We hardly talk about this, multiple offenders and stiffer sentences and so forth. Thank you for your intervention. I now have the pleasure I think we are keeping time to hand over to Eva Jala to do the presentation. She'll be carrying it for, I think, almost up to the end. Eva, the floor is yours, my sister. Hello.
Yes, I'm trying to share my screen.
And I think, Eva, before you share your screen, I think the program shows that at 12:15, you will apply the breaks for people to take a health break. All right.
Okay.
At 12:15 for just 30 minutes. We ask people not to take break and disappear for good. They need to come back, please, because we are now getting into the meat of things. Yes, Eva, the floor is yours.
Thank you very much, Judge SG, the technical committee. May I just say all protocols observed, ladies and gentlemen. Welcome to our very important session, which is the presentation of the GBV Model Law. This Model Law is a very comprehensive document, and we don't have enough time to actually go into it in detail. So I'll be going through the document very fast. I assume you have all read the document. It was sent to you much earlier, so it will make life much, much easier. So I'll be looking at mainly the explanatory notes first. Very briefly, you are lawyers, and I'm sure you have read them. Then I'll proceed to looking at key issues of the model law, just to give you some insight and to promote debate on the model law. We need to mobilize you into action because as SADC lawyers, we expect a lot of comments from you to help us enhance this law. So the GBV Model Law may be used as a tool, a guiding tool to many users of the legislation, be it you as lawyers, parliamentarians, researchers, administrators, and so forth. It is designed, it is not designed in the exact style and form as legislation in SADC member states, but its design is such as will communicate clearly the policy content and recommendations on best practices in legislative provisions for GBV. These will be, can be adapted, adopted, and included in national GBV laws. They are efficacious. They have been tested by the technical working group. We've done tremendous research into the contents of GBV legislation, both at local level and at international level. So we are quite comfortable that this is a good working tool, a good guidance tool for all member states. Therefore, the GBV Model Law will be a useful tool to SMSs as it provides the following: guidance on the scope and content of GBV provisions to be provided for in national GBV laws, encourage national legislators to enact GBV laws where these do not exist or where they do exist but do not conform with the model law, to review such laws and enact relevant GBV laws that conform with the model law. Support to national laws. Hello? Support to national laws during the implementation stage, especially where gaps still exist in your laws. The judge has pointed out that there are several gaps in national laws which need the support of something extra, be it international law, or you can safely use this GBV law, which we have prepared based on sound research. A yardstick to national policy analysts, legislators, and implementers as to best practices in enacting and dealing with GBV. Reinforce a commonality of a regional approach in dealing with GBV laws, measures, and strategies to help eliminate GBV, and a stimulus for debate, awareness, and advocacy. What was the rationale and objectives of the GBV model law? The GBV model will be a governance tool. It's a governance tool to assist MSS develop and enact national laws on GBV. That's the basic rationale behind it, right? Because SADC Parliamentary Forum, as you know, deals with parliamentarians. So we need to assist them, use it as a governance tool, or revise or reform existing laws on GBV in order to meet the international, continental, and regional commitments relating to human rights, and more specifically against gender-based violence. The underlying rationale is to protect victims and probable victims of GBV, punish perpetrators, and ensure that human rights are upheld in accordance with international, continental, and regional standards and requirements. So those were the objectives and the rationale. So what does GBV cover? It covers domestic violence, sexual harassment, as the judge kept pointing out, very important, in the workplace, human trafficking, and sexual and emotional abuse, economic violence, etc., etc. And we'll come to all these as we proceed in our discourse. When referring to GBV, the discussion is not just about the act of violence, but also about education and prevention, as well as victim assistance. We've heard what Peter said. We need to take into account all her points, because they are so important and profound in dealing with GBV. GBV not only, I think we've got cross lines, Madam or Judge, which is quite disturbing in the presentation. I can hear so many voices in the background. Judge?
Most kindly mute all other participants except for the presenter.
GBV not only has terrible effects on the victim, as you all know, but impacts negatively on society at large with serious social and economic consequences. It is a national issue which requires drastic national interventions through the highest tool of governance, which is the law. We must bear that in mind. Add lawyers, that the law is the highest governance tool, and we should use that tool to deal with this horrible issue called GBV. So Judge pointed out very clearly that GBV is an affront to human rights. Let us look at some definitions. Yes, he's given you definitions, but let us look at the UN definition of GBV. I'm sure you've all met it when you've come to your research and opinions. It means any act of gender-based violence that results in or is likely to result in physical, sexual, or psychological harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or in private life. The SADC definition is very similar to it, but it amplifies it. That's why I love the SADC definition, because it amplifies the definition that the UN has come up with. And listen to this, it says, it's all acts perpetrated against women, men, boys, and girls on the basis of their sex, which causes or could cause them physical, sexual, psychological, emotional, or economic harm, including the threat to take such acts or to undertake the imposition of arbitrary restrictions on or deprivation of fundamental freedoms in private or public life, in peacetime and during situations of armed or other forms of conflicts. And you can see this is an amplification of the UN definition. I don't know whether I should go into this. I think the judge has already touched on the inadequacies of national laws, so we can save time on these issues. Let me but briefly just touch on this one, because I think Judge didn't go into it. National legislative and institutional frameworks. Currently, issues related to GBV in SMSs are regulated and managed by various ministries and statutory authorities, with complementary support from the private sector, especially civil society organizations. They play a great role in trying to assist victims of GBV. They also provide shelter to these victims. So in most SMSs, there are no independent single regulators or management units dealing with matters relating to or impacting on GBV. You can see they are quite scattered and fragmented amongst institutions, which sometimes makes it very difficult to provide equitable access to GBV instrumentalities because of this fragmentation. So the institutional frameworks in most SMSs include gender commissions, prosecution authorities, legal aid services, women's clinics, the police service, victim support units, the judiciary, civil society organization, and workforce and institutional-based units. So you can see, depending on where you are or who you are dealing with, there are quite a number of institutions that impact on each other, maybe sometimes even creating priorities. So for effective and efficacious handling of GBV cases, SMSs require legislative and institutional frameworks that provide adequate measures, strategies, programs, and interventions to deal with GBV, including adequate capacity building of critical role players and stakeholders for effective and sustainable prevention, monitoring, and management of GBV cases. Here, we are not only talking about public sector, we are also talking about private sector, because as you've seen, civil society play a complementary role, and they play a profound role in assisting the GBV victims. So it is important to ensure that
the law provides an adequate institutional framework for engagement of all players who regulate, manage, and are affected by GBV by providing for a clear system for coordination, communication, and collaboration among all the players when dealing with GBV cases with clear lines of responsibilities. We don't want a situation where we end up in paralysis because we don't know who's responsible for what or where a victim can go and access justice. It's access to justice at the end of the day. So the regulatory and institutional framework must be clear and certain on issues such as extent of regulatory and investigative powers, functions and duties of key role players, procedural requirements, access to justice, coordination, communication, and collaborative issues, enforcement and compliance mechanisms, and management of infrastructure facilities, among others. So the victims of GBV and the private sector involved in providing advice, assistance, and protection to victims of GBV need assurance that regulatory state authorities have the necessary autonomy, power, and capacity to act fairly, transparently, and decisively when responding to GBV cases. I think this is so important, and we as lawyers must observe this requirement. Judge has already discussed the rights. I only point out key issues in them. This because we are now going for a paradigm shift in how we deal with GBV in our legislation, which is mainly human rights based. So I won't go into this. I've also attempted in the model law to list in the substantive part and in the schedule to make life easier for you as lawyers when researching or drafting your national legislation of all the appropriate international and regional and continental agreements, conventions, treaties, and so forth, which deal with GBV or which impact on GBV. So if you can take your time and go through this, you'll find a lot of information has already been done at regional, continental, and international level. So you'll find that the GBV model law attempts to restate some of the human rights that directly impact on GBV. These are in no way exhaustive, and the drafters of national legislation should endeavor to summarize all their state obligations at international level, analyze these, and fill in the gaps in national laws where these exist. Again, let me guide you to further research material. The UN itself has issued a number of legislative guidelines, guidance notes, explanatory notes, and commentaries on various human rights instruments, which act as good working tools to the drafters of national legislation, or you indeed as lawyers in SADC, for a gap analysis on national laws impacting on GBV. Some of the main recommendations have been already incorporated in this GBV model law, but it's good for you to have your own side research to check that these have been pronounced or incorporated in a manner that will be effective in your own jurisdictions. So the GBV model law, as far as possible, does take cognizance of the various constitutional requirements in the member states. Another area that is of concern, Judge touched on this as well, is the current criminal laws on GBV. I'll be going through key areas in relation to the offenses that have been created in member states, and which will show that some are not adequately covering GBV. As Beatrice says, some of the offenses and penalties are not explicit enough neither are they stiff so as to ensure that perpetrators, we don't end up with these multiple offenders. They must be, we must ensure that we try as best as we can to eliminate the scourge and not encourage it through our criminal laws. So we urge you to review all your criminal laws and ensure that there's harmony and consistencies in all the laws dealing with GBV. Because you find at times you've got your penal code or you've got your criminal law act, and then you've got your specific domestic violence act, then you've got your cyber laws, your trafficking laws, your terrorism laws, your money laundering laws, and anti-corruption laws, and so forth. These are not speaking to each other. They are not effectively cross-referenced to each other. So it creates disharmony in the legislative space dealing with GBV. And you know as lawyers that once there's disharmony in the legislative space, it's very difficult to charge on or get a conviction on a GBV case. Already they're already in a weak position in proving their cases. Now the law assists them further by making the law so ambiguous, so inconsistent, so conflicting one upon the other. So we need a thorough review of all the criminal laws to ensure harmony and consistency in the way we present GBV issues. In this regard, for the research in relation to criminal law, I would persuade you to look at regional and international guidelines and recommended practices that provide for police and law enforcement duties and responsibilities. For example, the Essential Services Package, ESP, is a guidance tool identifying the essential services to be provided to all women and girls who have experienced gender-based violence, including services that should be provided by the health, social services, police, and justice sectors. And you'll see when we come to some key areas of the model law that we have indeed taken account of Beatrice's concerns as to the gaps that are existing currently in member states. So it's very important, especially in relation to health and social services, that the law is complete in itself and not left hanging. So this package also provides guidelines for the coordination of these services. It provides standards and guidelines for health personnel, police and justice players, social health services, and for coordination and governance of these. So it's very, very important. You may also look at the SADC guidelines on these issues. Another issue, again, I don't want to skip this because Beatrice raised it, is that national legislatures should consider a range of enforcement and compliance provisions to give effect to the GBV model law and effectively prevent or deter GBV happening. The following key factors should be considered when reviewing and crafting GBV provisions into law. The extent to which the root causes of GBV are addressed with a view of migrating or eradicating them. The extent and nature to which GBV is provided in criminal and administrative law. Whether the GBV offenses provided for contravene fundamental provisions and the language of this GBV model law. The language is also very important because if you don't use the right language, then the extent and scope may not be covered as was intended by the technical working group on this gender-based violence, because their intent was fully discussed and strategized within the model law. Whether the offense of GBV is provided for in the law and what the extent of the prohibitions are. Whether the offenses, penalties, and compensation provisions are adequate and fit the offense specified. Whether adequate investigation powers or investigative powers are provided for to enable evidence to be easily gathered, assessed, and used to obtain a conviction for a GBV offense. You know, the way they deal, our policemen deal with the offense of GBV is rather casual. And it has been that even historically. Even now, as you draft or you have on your statute books, domestic violence laws, they are disregarded because I think the scope is not strong enough to ensure that there's adequate provisions for assessing and gathering evidence relating to GBV, so that the ultimate game is to gain a conviction. GBV is GBV. You hit me, you've created GBV. I provoked you, yes, but you hit me. So there must be a conviction. Whether procedural fairness and justice are firmly embedded in the law, and whether there is commitment to address impunity and delays in the course of justice. We need to change our attitudes in relation to GBV. We need to hold hands firmly and remove the issues of impunity. Impunity in our African societies have cost us greatly. And I think we need to get rid of impunity now. So I'm just urging you and informing you that an inefficacious legislative framework on GBV may result in increase in GBV cases, lack of access to justice, and continued inequities and inequalities in society, thereby having a negative impact on socio-economic development and continued non-observance and contravention of an individual's fundamental human rights and freedoms. The GBV model law will enable member states to decide on whether to retain the status quo as provided in the existing institutional and legislative frameworks, amend some laws dealing with or impacting on GBV, or generally gender equality and equity, or repeal and replace some laws to ensure that they deal comprehensively with GBV and provide effective access to justice provisions, thus creating an efficient and sustainable criminal justice and administrative systems for the fight against GBV. I won't go into this because I think I've touched on it, but another important area is customary laws and religious norms, the plague of Africa. SMS's customary laws and religious norms may impact greatly on women's and children's human rights, offend international commitments on GBV, good governance, and be repugnant to natural and legal justice. Customary laws are recognized as a source of law. That's very important. They are recognized as a source of law in most SMSs, where they are not inconsistent with the Constitution or an act of parliament, or are not repugnant to natural justice. Those are the words most of our common law legislation or statutes have used to recognize customary law with a rider that as long as they are not repugnant. But see what is happening in our societies today. Constitutions of SMSs recognize the freedom of religion. We recognize that. So the religious practices prevailing, some of these impact negatively on women and children. We need to relook at this and see how we can reform these through statute law, the highest tool of governance. SMSs must assess their customary laws, religious norms and practices, and attended institutions. And where these are contrary to the provisions of the Constitution, an Act of Parliament, and this GBV model law, or repugnant to natural justice, reform, amend such customary laws and religious practices immediately. We really need to do that because we'll be writing beautiful laws. But when it comes to implementation, we are animals. We live in societies. We live in an environment which is historically and traditionally embedded in certain ways of doing things, where the women gender is actually looked down on, trampled on. So we need to do something now. This model law may be good, but if we don't change our systems, it won't work. It won't work. I want to go into domestication. I think the judge has dealt with it beautifully, so it will save us a bit of time. I want to look at appropriate levels of competence and procedural fairness, which I think is important, especially to us as lawyers. You know, issues of competence derive from the Constitution and our acts of Parliament, our statute law. So the GBV law attempts to ensure that decisions are directly taken by the appropriate authority, competent authority, judicial institution, or quasi-judicial body. These we've tried to define in the model law, and you can adapt these when you are actually looking at your own laws or drafting your own laws. So why we have done this, we want to ensure that there's effective and efficient decision-making at any one stage where GBV is being handled, whether it's at the investigative stage and going right through the criminal justice system into a decision is made by a judge. So we've looked at the entire spectrum of the criminal justice system and tried to improve on the stages at every point of discourse. Again, where a discretion is given, it is to be exercised proportionately or comparably in relation to the nature of the decision being made. You can't hammer a small nut with a big sledgehammer. Then we will not achieve our objective. So we try to be very rational, even where we are creating the offenses and providing a sentence for that sentence, where we are actually providing for orders to be made, looking at the various circumstances in which that order shall operate. So all decisions or all discretions given to making a decision will be and are reflected proportionately and comparably in the GBV model law. So an appropriate authority, a competent authority, judicial institution, or quasi-judicial body must act in a manner which affords procedural fairness to victims of GBV, be and appear to be free from bias. You know that in gender, our main problem is bias, We migrate this into the laws dealing with GBV, and we make sure we protect against bias. It's very, very important. Survivors and victims of GBV must be given a fair opportunity to provide any relevant information before a decision is arrived at, and that decision must be explained in a way the victim of GBV can easily understand, regardless of their background, nationality, or lack thereof. I think these are important values to us as lawyers. I don't want to now start, I know Judge talked a bit about women and children, but maybe this part is very important. I know some countries in SADC are very averse to homosexuality, lesbianship, all these things. But for us as GBV, the SADC Parliamentary Forum, it's non-discrimination that prevails. So it's important to emphasize that while the focus of GBV model law seems to be more on violence against women and girls, the GBV model law also has a gender-based approach as it applies and is of relevance to violence against men and boys. The provisions of the GBV model law should be read broadly to apply to all forms and components of GBV. Judge, please, when the time comes, just stop me. I get so involved and passionate about this. So when it's time, please stop me. To the extent of the UN and SADC definitions to all victims and perpetrators of GBV, be it non-gender binary people, heterosexual, lesbian, bisexual, homosexual, transgender, or people within same-sex relationships or sex workers. Very, very important. I admit, like countries like Zambia, my country, you talk about homosexuality, you'll be grabbed. But you look at the same issues in South Africa. It's part of life, right? Their constitutions protect these rights. So maybe we can talk to each other as SADC Lawyers Forum, talk to each other, persuade and advocate that it's not a crime to be different. It's your right. And the laws should protect that. I think this is very important. However, in general, regardless of orientation and occupation, women and girls are more vulnerable to and experience more sexual violence, more severe physical violence, more abuse, and more control, largely from males. And that's the reason acute focus is made on women and girls who are disproportionately affected by GBV. But it's a model law of general application, believe me. It's a law of general application. So the scope of the GBV law follows quite closely with SADC-PF's scope of law on gender-based violence. They have a general scope on what gender-based violence laws should be. These are very helpful and will assist the drafters in SMSs to determine the content and scope of national laws. These are as follows. I think they're very important. The proposed process of drafting a model law on gender-based violence in the SADC region, initiated by the SADC-PF, is in response to the prevailing shortfalls in legislation on gender-based violence and the chronic implementation gap across the region. A model law can guide these initiatives and interventions and ensure that they adhere to regional and international human rights frameworks and address the increased vulnerability due to statelessness, unequal nationality rights, and forced displacement. So you can see the subject of objective and scope is very, very wide. So that is why the GBV model law is so comprehensive, and I can just say big. Yeah? It's quite big. It's really intense. Yeah? Victims and survivors often have little or no access to the justice system to report offenses and initiate legal action to secure protection or to ensure the state investigates crimes and prosecutes perpetrators. There is a need for a model law to strengthen legislative responses in the region, provide clear guidelines for law enforcement mechanisms, access to justice, and to facilitate harmonization and consistency of GBV-related laws within and across the states. Very profound. An analysis of initiative reveals that in several cases, countries fail to adequately deal with the problem of contradicting laws and laws that are limited in the type of gender-based violence considered. The result being fragmented and inadequate policy and legal developments that fail to address the problem of GBV systematically and inclusively. Here, the SADC-PF instruction actually covers a very important aspect, which is the policy aspect. Without sound policy, you cannot have sound laws. You need a sound foundation which the law will build on. And that is what the SADC-PF is actually emphasizing in this paragraph. Laws and policies have an important role to play in the achievement of gender equality. The development of a regional model law on GBV is one critical step in the process of effective legislative reform. Once the GBV model law is adopted, the SADC-PF will encourage member states to domesticate and implement key aspects of the model legislation at the national level. The model law will thus assist states to address all relevant areas in GBV legislation where they have gaps or where existing legislation needs reform. So they've laid it out. Why are we doing this GBV model law? And their scope and guidance has actually guided this model law, especially when we're developing the tenets of the provisions. So all we can say here is that, yes, the model law follows the spirit and intent of the SADC Declaration on Gender and Development, which sets following 6 specific targets and aims to eliminate gender-based violence at every level. Enact and enforce legislation prohibiting all forms of gender-based violence, ensure that the laws on gender-based violence provide for the comprehensive testing, treatment, and care of survivors of sexual assault, review and reform SMS's criminal laws and procedures applicable to cases of sexual offenses and gender-based violence, enact and adopt specific legislative provisions to prevent human trafficking and provide holistic service to the victims with the aim of reintegrating them into society, enact legislative provisions and adopt and implement policies, strategies, and programs which define and prohibit sexual harassment in all spheres and provide deterrent sanctions for perpetrators of sexual harassment, and adopt integrated approaches, including institutional cross-sector structures with the aim of reducing current levels of gender-based violence by etc. Okay, so you'll see that the GBV model law is speaking to these targeted areas. We've followed these spiritually and legally because we did not want to miss out anything. There are many more other international instruments which you can read on so that you can actually have a very robust, inclusive, and uniform legislative framework relating to GBV, as it is key in addressing GBV in member states. And you shall see when we come to key areas that we have even made this law extraterritorial. It's very important, especially where there's adequate reciprocity. Without applying it extraterritorial amongst ourselves as SADC member states, then we will not be achieving much. We've also considered issues, I think our guest speaker actually touched on this, issues relating to COVID. And we've brought in innovative measures into the GBV model law. So we'll find that the COVID pandemic has seen an increase of GBV in some SMSs. Maybe it's because of this confinement. There has been a global increase of GBV reported cases as a consequence of COVID-19. So it's not only regionally, but even international. We've had this problem. There is continued outcry from survivors and victims, civil society organizations, the international community, and other stakeholders for effective solutions to address GBV, including putting into place more stringent and innovative measures to ensure that COVID-19 pandemic does not act as a stimulus for increasing instances of GBV. Please, it should not act just because we are in confined places. This shouldn't be a recipe for GBV. The GBV model law attempts to provide innovative solutions, and you'll see them, and measures in investigating, assessing, prosecuting, and deciding on implementing and managing GBV and attended cases. I know lawyers depend so much on jurisdiction, precedents, as what the judge said, as if your life depends on it. We know also that to change a legal principle, a constitutional principle, takes time, as these were developed from a long time ago, centuries ago. They've been part of our legal systems. But where these legal systems are not helping to prevent this crime of GBV, we seriously need to reconsider those principles and bring in innovative principles that will help us fight GBV. We cannot, as lawyers, be stuck in the mud. No, but no, you have to have collaborative evidence. No, women always lie. So that's why this corroborative evidence is there. I think if you start from that perspective, then we are weakening our case against gender-based violence. We have to have an open mind as lawyers and ensure that we are able to come up with innovation, with new principles, new guiding provisions for assessment and for prosecution, and for an effective decision to be made by our judges. The preamble, if you look at the preamble will help you in your research. We have pointed out every conceivable document or plan or strategy dealing with GBV. That's a good base for you, and please, I would urge you to read it. So I've completed, Judge, am I still in time? Judge, let me check. Oh, I think I've made it dead on time. It's 12 o'clock. We are taking our lunch break now. When we come back, I don't know whether you want to have just a small chat on the explanatory notes before we proceed, Judge. I don't know what your judgment will be in this case.
Eva.
Yeah.
You have 15 more minutes.
Oh, there's 15 more minutes.
To lunch.
To lunch. Okay.
You want to break now, or do you want to allow?
No. I want to allow them just to discuss.
Some questions, some intervention?
Yeah, because I think this is important.
Okay. Okay, then. So let's have any contribution to what she has already said before we break for lunch. You can show by raising your hand. Or if you can't raise your hand, just speak.
Excuse me, can I please see the last slide?
The last slide?
Yes, please. Thank you.
Yes, any intervention, any comments from anyone?
Thank you very much, Dan.
Okay, thank you.
Any comment? Any question? Okay, I guess Eva, that we are still to go into the real meat of the legislation.
Yes.
You remember earlier there was comment on the role of social media and the internet opening opportunities for gender-based violence. You remember those remarks? I'm sure we are still to get into those, yeah?
Mr. Chair, yes, I must inform the audience that we did have a workshop with the media on this GBV, and I think it went pretty well. In the GBV law itself, there are provisions relating to advocacy and assessment of issues by the media, and they seem to be happy with it. So I suppose it was properly reflected. We also pointed out to the media that we cannot put everything in the GBV model law or indeed the GBV Act of Parliament. There must be adequate cross-referencing to other laws like the cyber laws, the trafficking laws, and such. So they need to be familiar with such laws, right? So a lot of advocacy, SADC needs to do a lot of advocacy awareness training for the media fraternity. We just introduced them to the GBV model law, but fundamental training is required to direct and focus the media on how to do reporting and assessments on GBV. I hope that's adequate.
Okay.
Well,
thank you, Eva. Any interventions before we take the break?
Thank you, Eva. Once again, I'm very curious. I'm very interested. My area of specialization is the ICT technologies, the internet and social media. And my focus is on freedom of expression on these platforms. However, when you were speaking, I was listening and I couldn't help but think, just now when you commented just a few seconds ago, you were saying, no, the laws are there, people have to be educated about them. One of the things that I've seen, I must also say that I've read a lot on the media law. I trained journalists before I changed into ICTs. And one of the things that I've seen is that some of these laws are almost, what is the right word? They are so ambiguous and almost non-existent and almost not functioning and serving the purpose because they are sort of overarching, to find a specific code or law or phrase. I mean, we can argue the law or we can argue the facts. To find a specific code on hate speech, for example, on cyber, on GBV, in some of these laws that are already there, it is itself a problem for me. And I'm saying, is it therefore not possible, Madam Eva, to have a specific law so that none of this is hidden under the other law? This is just my take. Thank you very much.
Yeah.
Thank you, ma'am.
Yeah, very true, very true. I agree with you. And that's why we are trying to come up with this GBV law, which is like all embracing, but at the same time recognizing that it's sitting on a statute book with other laws relating to it. If we actually have to input everything in it, it will be that thick and no one will be able to find anything at the end of the day. So if you have effective cross-referencing to point the user to where to go, effectively, even by section, it's more useful in that way than trying to hide it under an avalanche of provisions. So yes, I advocate one single law dealing with GBV profoundly and not fragmentedly, but with effective cross-referencing to relevant laws. That's what I would advocate. Yeah.
And I'll also add, I think, Moremoholo, there is a lot of merit in what you say. One of the singular disadvantage, for lack of better word, with lawyering and law is failure to use accessible language. Failure to use, there is a modern trend now that legislation should be so simple that high school people must be able to read and say, this is prohibited. This, you can't touch someone like this inappropriately at school or at work. The law says is wrong. Without having to go to the lawyers to interpret. So there is a lot of there's a lot of merit in that point, talking about ambiguity, that we need to introduce a lot of simple language, simplicity into our laws. Any other comments before we take a break?
Good afternoon, colleagues. Thank you so
Yes.
much for this platform. I'm also interested in having a look at the presentations that were presented today. It has been very, very good to see all the researches and all the presentations. And my input is on inclusion. I work a lot with people with disabilities, and I feel that even in our model law, everything that is put there should be inclusive. We have seen very unfair things, like in terms of access to justice for people with disabilities, no interpretation, inaccessible courtrooms, things like that, that make access to justice very, very difficult for people with disabilities. The reporting structure on its own is also very, very difficult. So many cases to do with people with disabilities become underreported, and yet they are so existent. And then yet again, there's very minimal research under the area. So I really feel that it should be an area that we should also incorporate in the model law. Thank you.
Thank you very much. You want to say, react to that? It was a comment, Eva?
It was a comment, Judge, and
yes.
thank you very much. Thank you very much.
Yes.
May I? Okay.
No, that is very true. I must react to the inclusion part. I think there is a lot of gap between the theory and practice. That law should serve everyone, more especially the disadvantaged, the marginalized. When you speak about that there are cases of that are underreported from, the disabled persons, that is so true. And yet we simply speak of them and hardly put match our words with action. And more importantly, also to ask them so that they can guide the legislative process around their needs. I think inclusion is a very important part. I have gone through the SADC model law as drafted. It has those principles. It contains those, but it's very important. At the end of the day, I think lawyers must also take it upon themselves to say, this is what is said in paper, but we need to commit that in actual practice it happens. As I said earlier, the law in paper is different from the law in practice. If it's not transformed into practice, we run into all sorts of problems. Anything, Eva? Otherwise, we are going to take a break.
No, I think they can digest those because they are relevant to the next part. But in the next part, we are just going quickly through certain provisions that I wish to draw your attention to, because the time is just not available. Thank you, Judge.
So thank you very much. We are taking a break.
Chair, before the break, there are lots of comments in the chat.
Yes.
Oh, okay.
Yeah, perhaps somebody should collate them, and we see whether the presenters, including yourself, want to.
Yes, is Ronald or Pauline collating this comment somewhere?
Sally should be able to do that. That is why actually I was raising my hand, Chair.
Yes.
To say Sally should collate these and assist us. They are doing the rapporteuring and assist us in getting your attention and Ms. Evers to respond to them. Thank you.
Yes, Sally, are you there, Sally?
Yes, thank you. Thank you, SG. Thank you, Prof. So I would start, there are similarly women in places of detention.
Hello, after the break, Ms.
Yeah,
Kemi,
after the break,
if you
Sally.
pull them together in writing, flash
Yeah.
them before we start the next session so that we start with those.
Thank you, SG. Thank you, Prof.
Great stuff. So we are going for lunch. It's 30 minutes. It looks like a 30 minutes break from my program here. So we are back at 12:45 to continue the presentation. Maybe when we come back, let's just continue with those collated questions and comments, Sally.
Yes, sure, on it, sir.
Okay, great stuff. And then we'll proceed in that manner. Let's take the 30 minutes break and come back on time. Thank you very much.
Thank you, Judge.
Thank you.
Thank you.
Thank you. Enjoy lunch.
Thank you very much. Thank you.
It's a virtual lunch.